Your Honours, distinguished guests, ladies and gentlemen, my name is Carolyn Evans. I'm the Dean here at Melbourne Law School, and it's a great pleasure to welcome you to the 2016 Alan Hope Southey Memorial Lecture on the topic of When the High Court Went on Strike by a most distinguished speaker, the Honourable Justice Stephen Gageler. I'd like to acknowledge Justice Gageler. I'd also like to acknowledge members of the Southey family who are with us. It's a great pleasure to have you here. And also my colleague, Professor Adrian Stone, Director of the Centre for Comparative Constitutional Law, who will chair question time and thank His Honour at the end of the presentation. I begin by acknowledging that we meet on the traditional lands of the Wurundjeri people of the Kulin Nations. I pay my respects to their elders, past and present. Ladies and gentlemen, this evening's proceedings are being filmed and will be available from our website soon. For this reason, if you are going to ask a question during question time, please wait for the microphone to be passed to you so that the question will be recorded. And the event's also being photographed. Please just speak to the photographer if you're not comfortable with that. Unless you want to feature on this video, could you please switch off your mobile phones now or put them on silent? Now, tonight's event forms part of the Alan Hope Southey Memorial Lecture Series, an annual lecture series which has attracted some very interesting and distinguished speakers over the years. It was established by Ethel Southey, or Nancy Southey, in 1958 to endow a law lectureship in memory of her husband, Alan Hope Southey. Over 50 years later, we continue to have the support of the Southey family, and we'd like to thank them for both their time and for their generosity. Both the family and we are delighted that today the Honourable Justice Stephen Gageler has agreed to give this presentation. He will be well known to almost everybody here. A very eminent barrister educated at the Australian National University and Harvard. He was appointed Senior Counsel in 2002 and had an exceptional practice at the bar in constitutional, administrative and commercial law primarily. He was Solicitor General of Australia, a role that he held with great distinction before being appointed to the High Court in 2012. In that role, of course, he has demonstrated his traditional intellect, ethical approach to the law, and has gained the admiration of many people in the profession and beyond. We are very proud and grateful that His Honour has agreed to deliver the Alan Hope Southey Memorial Lecture tonight and share his wealth of knowledge, including some quite recently gained knowledge about a very unknown and unusual historical episode when the High Court Justices went on strike, and we'll use that to also explore broader and important issues of judicial independence. Please join with me in welcoming His Honour.
Well, thank you, Professor Evans. It is a great pleasure to be back here at Melbourne Law School, and it is an honour to be part of this prestigious lecture series. I have been fossicking in the High Court basement, and I'm about to share with you some of the information that I have found. The High Court did an extraordinary thing in May 1905. The High Court Justices made and implemented a collective decision that they would refuse to sit until satisfied that certain demands concerning the payment of work-related expenses were met by the executive government of the Commonwealth. In short, the High Court went on strike. The story of the strike can be told in a variety of ways. Easiest is to portray it as a clash of very strong personalities. Fairer is to portray it also as a clash of principles. I am going to be somewhere in between. I want to link the personalities to the principles so much as I can using their own idiom. The players. The main antagonists were Sir Samuel Griffith and Sir Josiah Simon. Each was an eminent lawyer. Both had been prominent figures in the Federation movement. Griffith had been Premier and then Chief Justice of Queensland before he was appointed as the first Chief Justice of the High Court in 1903. Simon had been a one-time Attorney General of South Australia and was elected as a Senator for South Australia in the first Commonwealth Parliament. He became, in 1904, Commonwealth Attorney General in the administration of Sir George Read. Between Griffith and Simon, there was professional rivalry and personal animosity. Contemporary descriptions were of Griffith as cold, clear, collected and acidulated, and of Simon as quarrelsome. Simon was described by an eminent historian in 1978 as a good hater, perhaps the best Australian politics has ever produced. That, of course, was in 1978. Griffith and Simon had this in common. They shared an aspiration for the existence of a strong High Court. Each had worked hard for the establishment of the Commonwealth and of a national judiciary. Each had demonstrated a deep commitment to Alfred Deakin's celebrated characterisation of the High Court as the keystone of the federal arch. They differed about how that metaphorical arch was to be constructed and maintained. One of their differences might be thought superficially to have been entirely prosaic. Griffith favoured a High Court which would traverse the nation, engaging with the judiciaries and practitioners of the courts of each of the states. Simon's vision was of the High Court exercising its appellate jurisdiction in modest surroundings in a single national location. That difference between them about where the High Court should do its work would be at the forefront of the opposing positions they took in the conflict that was to unfold. Yet a deeper philosophical difference was to emerge in their defences of their positions. Griffith stood for an expansive notion of judicial independence. Simon stood for an expansive notion of judicial accountability. Setting the stage. The Australian Constitution, as it came into existence on the 1st of January 1901, mandated the existence of a federal Supreme Court, to be called the High Court of Australia, which was to consist of a Chief Justice and so many other justices, not less than 2, as the Parliament prescribes. The Constitution provided for the appointment of the justices by the Governor-General and for their remuneration to be fixed by the Parliament and not to be diminished. Prescription of matters incidental to the execution of the judicial power vested in the High Court was left to the Parliament. Responsibility for the execution and maintenance of the Constitution and of the laws of the Commonwealth was conferred on the executive government of the Commonwealth, and that responsibility extended to the withdrawal from the Consolidated Revenue Fund and expenditure for the purposes of the Commonwealth of money appropriated by the Parliament. The Judiciary Act, enacted by the Parliament in 1903, provided for the High Court to consist of the Chief Justice and the constitutional minimum of 2 other justices. The Act provided for the principal seat of the High Court to be at such place as the Governor-General from time to time appointed. Sittings of the High Court were to be held from time to time as may be required at the principal seat of the court and at each place at which there was a district registry. The justices of the High Court were to have power to make rules of court to cover, amongst other matters, the appointment and regulation of sittings. The Chief Justice and Justices were to be paid a salary at a specified rate, and there was also provision for them to be paid, for each justice to be paid on account of his expenses in travelling to discharge the duties of his office, such sums as were considered reasonable by the Attorney-General. The administration of the High Court was left to the executive government, and within the executive, that administrative responsibility fell to the Attorney General's department. The enactment of the Judiciary Act had not been uncontroversial. The preceding parliamentary debates had been protracted and extensive. Many within the Parliament considered the establishment of the High Court at that early stage of national development an unnecessary luxury. They were concerned, amongst other things, that the workload would be insufficient to justify the cost. The enactment was only procured by the trimming down of the bill as introduced to reduce the proposed number of justices from 5 to the enacted 3, to reduce their proposed salaries, and to eliminate a provision which would have provided them with pensions on retirement. The appointment of Griffith as the first Chief Justice was accompanied by the appointments of Sir Edmund Barton and Richard O'Connor as the first 2 other justices. Their appointments by the Governor-General were preceded by him appointing Melbourne as the principal seat of the court. When the justices took their oaths of office on the 6th of October 1903, in a ceremonial sitting here in Melbourne, they had already chosen not to live in Melbourne. Arrangements had been made through the Attorney General's Department for the justices to occupy chambers in the Law Courts building at Darlinghurst in Sydney. Barton and O'Connor lived in Sydney. Griffith, who came from Brisbane, chose to keep living in Brisbane, at least initially. Within a week of being sworn in, the justices made rules of court which had the effect that, unless otherwise directed by the court or a justice, an appeal to the High Court was to be heard in the capital city of the state from whose court the appeal was brought. They appointed the first sitting of the High Court for the transaction of business to be in Brisbane on the 26th of October 1903. While in Brisbane, they made another rule of court, appointing sittings for the transaction of business in Adelaide in November and in Perth in December 1903. While in Adelaide, they made another rule of court, appointing sittings for the transaction of business in Hobart in February 1904 and in Melbourne and then Sydney in March 1904. So began a peripatetic and, to Simon's way of thinking, erratic and extremely costly pattern of judicial behaviour. The travelling expenses of the justices and their associates were initially reimbursed in full by the Attorney General's Department on certification by the justices without question as to the amount. In July 1904, Henry Higgins, who was then Attorney General in the very short-lived administration of Australia's first Labor Prime Minister, Chris Watson, wrote to the justices proposing that the travelling expenses of the justices be capped at a daily rate of £3 10 shillings. To put £3 10 shillings per day in July 1904 in perspective, as a judge of the Commonwealth Court of Conciliation and Arbitration, Higgins would go on in 1907 to decide the famous Harvester case, setting the minimum wage for an unskilled labourer at £2 2 shillings per week, the amount judged necessary for an average worker to pay for food, shelter and clothing for him and his family. A daily rate of £3 10 shillings was quite generous in July 1904. The justices nevertheless replied jointly in a letter in August 1904 expressing their hope that the existing arrangement would be continued. Act 1, bookshelves. The stage was in that way set for a confrontation between Griffith and Simon, who, by the time the justices sent their letter in response to Higgins, had succeeded Higgins as Attorney-General with the formation of the Reid administration in August 1904. The Reid administration was in a precarious political situation from the start, commanding a bare majority of one vote in the House of Representatives. It was able to cling to power until the close of the parliamentary session in December 1904, only to be forced to resign after the Parliament reassembled in June 1905. The conflict between Griffith and Simon began at the end of 1904. It began with an innocent inquiry about bookshelves. Griffith had decided, after a year in office, that continuing to live in Brisbane was impractical and that he should move to Sydney. Griffith wrote to Simon about that at the beginning of December. He had made up his mind to make Sydney his headquarters from the beginning of 1905, and he would therefore need to move his library there. There was insufficient shelving in his chambers in Sydney, and he asked that Simon be good enough to move the proper authorities to give directions to have his chambers fitted with proper and sufficient shelves to be ready to receive his library, say, in February of 1905. He did not think that the shelves had to be elaborate or expensive. He required about 300 feet of shelving altogether, of which about 50 had already been provided. To a follow-up request by Griffith, Simon said that he had no time to reply until after the close of the parliamentary session. When Simon replied 2 days before Christmas, what he had to say was about a great deal more than just bookshelves. Simon had gone back over the correspondence between Higgins and the justices concerning travelling expenses. The travelling expenses of the High Court, he said, had attained a magnitude which lately, both inside and outside the Parliament, had occasioned remark and evoked sharp criticism, with some of which he, Simon, confessed he sympathised, and he felt sure that he should not look in vain to the justices to assist in securing a substantial reduction in those expenses. The principal seat of the High Court, Simon observed, was in Melbourne. He did not think it ever to have been contemplated that the High Court would go on circuit. The role of the court, the rule of court, which the justices had taken it upon themselves to make, to the effect that appeals should be heard in the capital city of the state from whose court the appeal was brought, unless otherwise directed by the court or a justice, should, Simon submitted, be expressed in the opposite way, so as to provide that appeals should be heard in the principal seat of the court unless otherwise directed. The High Court, as the full court, should not incur any travelling expenses unless under very exceptional circumstances, and if it did travel, the expenses should be computed from the principal seat of the court. The justices' travelling expenses fell squarely within the portfolio responsibility of the Attorney-General's Department, and as the Attorney-General, Simon proposed that from 1 January 1905, he would allow the travelling expenses of each justice to include those of his associate and would fix the maximum amount to cover both at 3 guineas for every travelling day in the discharge of judicial duty. Griffith's response was dated 2 days after Christmas. He said that he would discuss Simon's proposal with his colleagues. In the meantime, he took leave to observe that the policy of holding sittings of the High Court as the Court of Appeal in all state capitals was adopted after full consultation and with the warm concurrence of the federal government. The justices had been willing to bear the inconvenience of travelling in the interest of federal unity, and the policy had, so far as Griffith had been able to observe, received the approval of public opinion throughout the Commonwealth. The policy could only be altered by a rule of court or by statute, neither of which could in any event come into operation until after the commencement of the next session of the Parliament. In the meantime, Griffith trusted that he was justified in assuming the existing arrangements would not be disturbed, and, said Griffith, he wanted the bookshelves. The battle lines were thus set for a barrage of correspondence to occur in the early months of 1905 between Griffith and Simon. Often several salvos were fired in rapid succession. In the confusion and heat of the battle, letters often crossed in the mail. To his increasing annoyance and frustration, the Prime Minister, Reid, found himself caught in the crossfire. Targeting the making by the justices of the rule of court, which Griffith had described as implementing the policy of holding sittings for the hearing of appeals in all state capitals, Simon said it was unfortunate that the learned justices should have permitted considerations of policy to influence their actions. Questions of policy, it seemed to Simon, were for the executive and the Parliament alone. For the justices to take it upon themselves to incur travel expenses in the interests of federal unity was, he ventured to think, quite outside the great sphere of power, influence and usefulness intended to be filled by the High Court under the Constitution. He proposed that the High Court should, for the present, continue to sit periodically in Sydney for the hearing of appeals from Queensland as well as New South Wales. All other appeals should be heard at the principal seat of the court in Melbourne. Griffith, for his part, could not omit to express his surprise and regret that Simon should even inadvertently allow himself not only to instruct the justices as to the principles which should actuate between them in the exercise of their discretionary powers, but also to convey his disapproval of the manner in which they had already exercised them. Simon would, Griffith was sure, on reflection, be the first to admit that it was not for the executive government to instruct the judiciary or to intimate either approval or disapproval of their action. Simon could be assured that the justices would, in the exercise of their discretion, be entirely unmoved by the thought of the possibility of executive disapproval. Griffith also thought it right to inform Simon that he should feel bound to take an early opportunity of offering a public explanation for the absence of his library from Sydney, where it would naturally be expected to be. Simon was not budging on the bookshelves. He noted with amazement Griffith's threat to go public and regretted that Griffith should think the threat of publicity wise or worthy of the High Court or of himself as its president. There was nothing inadvertent about Simon's disapproval of the justices' adoption of the policy of holding sittings for the hearing of appeals in all state capitals. Simon affirmed it. He recognised the recognised immunity of the judiciary from executive control, said Simon, applied only to the exercise of their judicial functions and not to extrajudicial action. Simon emphatically denied that it was not for the executive government to intimate either approval or disapproval of the justices' action. It would not be in the interests of the High Court itself or of the people of Australia if the Attorney-General of the day did not maintain a rigorous control over its non-judicial action and especially its expenditure. By the middle of February, Griffith had made his way to Sydney, where he conferred with Barton and O'Connor. The justices closed ranks. They wrote jointly to Simon. Their tone made plain their surprise that a simple request for office furniture had resulted both in a denial of the propriety of the existing system of holding sittings of the High Court in the several state capitals for the hearing of appeals and a proposed change to the existing arrangement for the payment of travelling expenses. On the question of policy, the justices said this: the present system or policy of hearing appeals in the states in which they arise was adopted after a conference between the then Prime Minister, Mr Deakin, the then Attorney General, Mr Drake, and ourselves before the issue of our commissions. It was recognised that it would cause considerable personal inconvenience to ourselves and involve considerable expenditure for travelling expenses. It was thought right to make it possible for those whose cause arose at places other than the principal registry to employ the same counsel and advisers who had conducted the case below. It was also thought that it would be an advantage to litigants that the members of the court should have the practical knowledge of the varied local conditions obtaining in different parts of Australia. It was further thought that the periodical visits of the High Court, which is at present the only federal court to the several state capitals, would have the effect of fostering and maintaining a federal sentiment. As a natural corollary to this arrangement, it was further arranged that the justices should, until the establishment of a federal capital, be considered free to fix their residences in any part of the Commonwealth. The justices went on to say that they considered it their duty to refrain from making any change to the existing rules of court which they thought would be detrimental to the general interests of the Commonwealth. The justices emphatically protested against the suggestion that it was competent for the Attorney-General to determine either the place from which their travelling expenses were to be computed or a rate at which they were to be fixed. Such a doctrine, they said, would involve an intolerable interference with the independence of the bench. Simon counterattacked with a point-by-point refutation. Judicial independence was not, in Simon's judgment, to be used as a shield behind which judges may seek shelter in respect of their non-judicial acts or excessive expenditure. He regretted the attitude of antagonism adopted by the justices and their unwillingness to cooperate in mitigating the severe and unlooked-for burden imposed on the Commonwealth by their travel. Full court circuits were, in his opinion, a violation of the letter and of the spirit of the Constitution. He was sure that the Judiciary Act would never have been enacted had it been proposed to the Parliament that the full court systematically, as distinct from one judge occasionally, would go on circuit. The policy of going on circuit was the policy of the justices and not of the then government. It was not possible to treat seriously the suggestion that full court circuits were necessary to enable Australian justices to gain knowledge of Australian conditions. As to the suggested fostering of federal sentiment, the High Court was not an instrument of federal propaganda, and the justices were not missionaries of federal sentiment. To establish circuits was to appropriate public money. To do so was within the province of the Parliament. The system the justices had created, by which the High Court sat where and when it pleased, was in practice full of confusion. The High Court was claiming to be able to put its unrestrained hand into the public treasury and seemed to have forgotten that even in the administration of justice there must be some thought and feeling for the taxpayer. The justices could live where they liked, but they should not routinely go on circuit as a full court, and their individual travelling expenses would be computed on the basis of the Parliament's determination that the seat of the High Court was in Melbourne. By March 1905, it might have been thought that a stalemate had been reached. Both sides agreed that further correspondence would be unproductive, but the justices had done nothing to moderate their practice, and Simon would not relent in his campaign against them. In April, the conflict was to escalate beyond a mere war of words. Act 2, the justices strike. The justices on 13 April made another rule of court which, amongst other things, appointed sittings for the transaction of business of the full court in Brisbane on the 29th of May. 3 days later, Griffith wrote to Simon provocatively requesting that arrangements be made with the Government of Queensland for a courtroom to be put at the disposal of the High Court for its sittings in Brisbane. Simon replied to Griffith on the 26th of April. He said that he would make the arrangements for a courtroom despite being unable to admit of the validity of the appointment of the sittings. Simon added that he was unable to consider that the 3 High Court justices needed to be accompanied to Brisbane by 3 associates and 3 tipstaffs, and requested that the numbers be limited to 1 of each. By the way, said Simon, he saw no reason why each justice needed to have a separate telephone in his chambers at Darlinghurst. He proposed for the present to allow 1 telephone for the use of the High Court to be placed wherever in the building the justices may think most convenient. He had directed the other telephones at Darlinghurst to be discontinued at the end of the month. Simon concluded by saying that it had also been brought to his attention that justices had used steamships to travel from Sydney to Hobart when they could have used their gold railway passes between Sydney and Melbourne, and then again between Launceston and Hobart. It occurred to Simon that the justices would probably prefer to pay the accounts of the steamship companies themselves. The battle had come to a head. O'Connor was scheduled to conduct an 8-day civil jury trial in Melbourne commencing the following Tuesday, the 2nd of May. To arrive in time, O'Connor would have had to have left Sydney by Sunday. O'Connor's impending departure, with no assurance that his travelling expenses would be met, provided the platform for the justices to take a public stand. The justices sat as a full court in Sydney at noon on Saturday, the 29th of April, 1905. Griffith announced from the bench that circumstances had arisen which left the court with no alternative but to postpone the hearing in Melbourne. The hearing was adjourned for a week. No further reasons were then given. Simon, who was in Adelaide when he heard of the adjournment, scribbled a note to himself, which read, "How can any court, because of a disagreement as to hotel expenses, go on strike? No wharf labourers' union would do such a thing." He sent a telegram demanding an explanation for the adjournment. Griffith sent him a curt telegram in reply, saying that the justices could not recognise his right to demand reasons for any judicial action of the High Court, except such request as might be made by any litigant in open court. On Thursday, 4 May, a headline appeared in the Advertiser in the form of a question: "Is the High Court on strike?" The subheading was "The Attorney General's Economy, Bookshelves Disallowed." Reid called a cabinet meeting with Simon in attendance. It was held on Saturday, the 6th of May. 2 days later, the Argus reported that Cabinet had discussed a dispute which had recently arisen between Simon and the justices of the High Court, the exact nature of which had not been made public, but which had been resolved through the wise intervention of Reid. Evidently considering Simon to have been defeated, the High Court resumed sitting. O'Connor commenced the adjourned trial in Melbourne on Tuesday the 9th of May. Griffith and Barton sat as the full court to hear and determine a leave application in Sydney on the same day. As if to rub salt into Simon's wounds, Griffith wrote to Simon saying that as he understood that it was no longer intended to make any proposal for discontinuing the sittings of the full court in Sydney, he would be honoured if Simon could attend to the bookshelves. Act 3. The Attorney-General strikes back. Simon had no intention of attending to the bookshelves. Simon had dug in. Simon wrote to Reid, accusing Reid of undermining his authority at a time when, in Simon's words, the justices were mad enough to do that which no government and no country could endure, refuse judicial duty. The justices, said Simon, were literally on strike. To give way to them would cover the Reid administration with shame. The justices thought it necessary to make another stand. On Tuesday, the 23rd of May, 1905, when O'Connor had still not returned from Melbourne, Griffith and Barton convened as a full court in Sydney. Griffith then read a long statement, copies of which were handed out to the press. Griffith first attributed the cause of the adjournment of the trial in Melbourne to what he described as the Attorney-General's persistence in his assertion of his right to treat the whole matter of travelling expenses as entirely in his discretion. Griffith then went on to disclose, in substantial part, the contents of a telegram which he had sent to the Prime Minister the previous day and the Prime Minister's reply that morning. Griffith had written to Reid, "I have the honour to request from you, as the head of the government, assurances of the following points. 1, that the travelling expenses of the justices of the High Court shall be regulated retrospectively, as from the 1st of January last, by order in council. 2, that the allowances shall be fixed by order in council on a definite basis at a specified daily rate in addition to fares. 3, that while judges reside in Sydney, their travelling expenses incurred while holding court in Melbourne shall be allowed on the same basis as travelling expenses to Sydney would be allowed if they resided in Melbourne. For reasons with which you are acquainted, it is essential that I should receive a reply before sitting of the court tomorrow. S.W. Griffith." Reid was then travelling in Western New South Wales and was quite clearly annoyed to be bothered again with such an issue. Reid had replied to Griffith, "Your telegram reached me." This, by the way, the original telegram is from the basement of the High Court. "Your telegram reached me on my arrival to Moree this evening. I observe that it demands from me, as the head of the government, certain assurances to be transmitted to you before the sitting of the High Court tomorrow morning at 10 o'clock. In the first place, I must ask you to address official communications on the subjects mentioned to the head of the ministerial department, which deals with official business of that nature, as directed by orders of the Governor-General in Council, of which you must be aware. In the second place, I wish to observe that if you address to the Attorney-General, who is the head of the department, as explicit a statement of your desires as you have addressed to me, couched in the ordinary forms of official correspondence and containing a request for the consideration or reconsideration of the 3 points set forth in your telegram, I have no doubt whatever that a satisfactory solution of the difficulty would be arrived at. I am bound to add that, even if your telegram had been addressed to the proper minister, it would be impossible to overlook the peremptory terms in which compliance with your wishes is demanded. G.H. Reid." Griffith said in his statement from the bench that the receipt of Reid's telegram that morning left the matter remaining on the 23rd of May where it had been on the 29th of April, except so far as it had been aggravated by subsequent communications. The reasons which had rendered necessary the postponement of the hearing in Melbourne now placed the Brisbane sittings in jeopardy. The justices would decide on O'Connor's return to Sydney what course they would take. Interviewed on the 24th of May in Tamworth, Reid referred to the Chief Justice as having made a preemptory demand and said that he viewed with profound regret and concern any difficulty between the executive and the judiciary. He said that no one knew better than the Chief Justice that his communication should have been addressed to the Attorney-General. Interviewed the same day in Adelaide, Simon was less conciliatory. He said that there was nothing in the Chief Justice's statement which could justify or palliate the refusal of the justices to do their duty, or which would permit the highest public servants of the Commonwealth to do or to profit from that which the humbler public servants were not permitted to do. The High Court reconvened on Friday the 26th of May after O'Connor's return to Sydney. Unappeased and indignant, the justices were not then prepared to escalate the conflict further. Griffith read another statement from the bench in which he said that his statement of the 23rd of May had been made under judicial responsibility. Griffith announced that the justices had decided to go ahead with the sittings in Brisbane on Monday the 29th of May. A fortnight passed. There had been a lull in the fighting, but the battle was not over. On the 9th of June 1905, Simon went again on the offensive. He wrote to Griffith, giving an explanation for the absence of communications between them. Simon explained that Griffith's telegram to Reid had been forwarded by Reid to Simon. Having waited a fortnight in the hope of receiving a communication directly from Griffith, Simon had, he said, on the 8th of June, dealt with the request made by Griffith in the telegram to Reid and had submitted his, Simon's, decision to Cabinet. Upon his recommendation, the government had decided to meet the wishes of the justices by an order in council determining three things. First, the travelling allowances of the justices would be computed from the principal seat of the High Court, Melbourne, subject to the proviso that for so long as sittings were held in Sydney, the justices would be paid travelling allowance while sitting in Melbourne instead of being paid travelling allowance while sitting in Sydney. Second, the amount of travelling expenses, in addition to necessary railway or steamer fares, would be 2 guineas a day for each justice travelling singly to take business in original jurisdiction, and 5 guineas a day for the 3 justices together travelling to take full court business. The rates were to be exclusive of the travelling expenses of associates. Third, travelling expenses from the 1st of January to date, including the same concession as to Melbourne expenses instead of Sydney expenses, were to be allowed at the maximum of 3 guineas a day for each justice and his associate. Each of the demands Griffith had made in his telegram to Reid had been met in letter but not in spirit. On the 14th of June, Griffith wrote a very long letter to Simon in which he recounted all of their previous correspondence, starting with his letter about the bookshelves. Turning to the first of the elements of the decision which Simon had announced, Griffith said that if he had correctly understood the method of computation of travelling allowance, the justices were to be penalised for living in Sydney, inasmuch as they would have to pay their own expenses of travelling between Sydney and Melbourne. Turning to the second, Griffith continued, the proposal that a reduced lump sum shall be allowed to the 3 justices when travelling together appears quite inexplicable. Fortunately, we are on terms of personal friendship and have on most occasions been able to arrange to reside together while on circuit. But this is an accident which cannot be regarded as a permanent condition. It might easily happen that, for reasons which must be obvious, it might be desirable or even necessary that the justices should occupy separate sitting rooms or live in separate lodgings. The proposal seems inconsistent with any adequate notion of dignity of the office or with any regard to the usages or persons such as may be expected to fill the office of a justice. Griffith's letter to Simon went on to set out a revised and enumerated series of very specific demands which covered the amount and method of computation of the travelling expenses of the justices and which separately covered the amount and method of computation of the travelling expenses of their associates and tipstaffs. Griffith concluded the letter with a request that Simon bring the letter to the attention of Cabinet. On the 19th of June, Simon replied. He said that he had brought Griffith's letter before Cabinet and that he had the honour to inform Griffith that the government saw no reason to depart from the decision conveyed in his letter of the 9th of June. 3 days earlier, Simon had written to Griffith that he had made a decision that the office of tipstaff was to be abolished and that the salaries of the associates were to be reduced. The conflict, unseemly from the start, had by this point descended into a seemingly never-ending farce. It was brought to an abrupt end with the resignation of the Reid government barely 10 days later. Reid was replaced as Prime Minister by Alfred Deakin. Isaac Isaacs became Attorney General and quickly produced peace with the High Court. The view of the Deakin government, Isaacs told Griffith, was that the Parliament, in enacting the Judiciary Act, had deliberately entrusted the whole question of High Court circuits to the justices. The travelling expenses of justices were set by order in council at a fixed daily amount of 3 guineas, payable to each justice individually. The justices were to retain their tipstaffs and the salaries of their associates were not to be reduced. The justices' steamship fares were to be met. Each justice got his own telephone in his chambers at Darlinghurst, and Griffith got his bookshelves. Epilogue. Griffith was victorious. The practice of circuits, established by the first 3 justices of the High Court, received the ringing public endorsement of representatives of the legal profession in every state, including South Australia. The practice remains to this day. Simon was anything but gracious in defeat. In opposition in the Senate, he introduced a private members' bill to amend the Judiciary Act to abolish High Court circuits for the purpose, he said, of making the High Court as an appellate tribunal a stationary and not a perambulating court. The bill was defeated on the voices without debate at its second reading. During debate on estimates, Simon moved a motion to reduce the salaries of associates and to abolish tipstaffs. That motion was defeated. Griffith's triumph and Simon's ignominy cannot gainsay the mixture of pettiness and principle which fueled the actions of both. To the extent the principle can be separated from the pettiness, their battle was about the boundaries of judicial independence and about the balance between judicial independence and judicial accountability. On judicial independence, it was the broader principle espoused by Griffith that stood the test of time. Modern exposition of the concept of judicial independence has resulted in broad consensus, at least amongst judges, that judicial independence cannot be confined to independence in adjudication and that some measure of institutional or administrative independence of the judiciary from the executive is necessary to ensure adjudicative independence. Simon undoubtedly let temper cloud his judgment. But Simon's emphasis on accountability in judicial administration was misplaced only to the extent that he sought to limit judicial accountability to accountability to the executive. Accountability in adjudication is traditionally ensured by an institutional requirement that adjudication is ordinarily to occur in public and that an adjudicative outcome is ordinarily to be justified by reasons that are published. The events of 1905 helped to remind us that the requisite balance between independence and accountability in judicial administration is better pursued not by means of the executive acting as a check on the judiciary, but through the institution of broader mechanisms of accountability which exhibit similar judicial openness to public scrutiny. So thank you for listening to me. That is all I have to say on this topic.
Good evening, I'm Adrienne Stone. It's my pleasure to chair the question time. Justice Gageler has generously agreed to take some questions. We have about 10 minutes. So I'll ask you to identify yourself if you want to ask a question. Could I remind you that you are being recorded, so could you wait for the microphone to arrive, identify who you are, and in the interests of having as many interventions as we can, remember that you are to ask a question and to do so succinctly if you can. So let me open the floor. Cheryl Saunders.
Cheryl Saunders, Melbourne Law School. Judge, thank you very much. That was a wonderful and extremely entertaining and interesting speech. With hindsight, looking back on that, do you think that was a very important moment for the court in setting the culture of judicial independence and institutional independence in particular? Yeah. I mean, it's always struck me that the High Court enjoys very considerable institutional independence in a way that seems admirable, and I'd often wondered where it came from.
Yeah, well, it came from Griffith's strength, I think. I think I've got another 2 lectures in me because around about the same time, as you'd be more aware, Griffith was having a battle with the state Supreme Courts. I mean, some of the state Supreme Courts were taking the view that they could ignore orders of the High Court. So Griffith was stamping his strong personality on the Australian judiciary, and around the same time, as you're also more aware, he's having a battle with the Privy Council in London. So this was a formative period and probably a necessary period in the High Court's early institutional development. So this is really one of sort of 3 battles. This is the independence from the executive, and there was then the independent, the authority over the state Supreme Courts, and then the independence from the Privy Council in the area of constitutional adjudication. All of these things going on pretty much concurrently. So he might have got a bit obsessive about the bookshelves, but there was a lot going on.
Tony Ryan. Justice, the famous sitting on the Saturday sitting in April in Sydney in 1905, did your researchers allow you to determine who appeared before the court, if anyone, on that occasion?
I left a bit. I've written a 12,000-word paper. You've got about 3,000 words. This is really, really interesting. Nobody appeared. Okay. Nobody appeared. And what happened? It's quite funny, actually. Nobody appeared, and it seems like Reid was either in town or just about to arrive. So they'd originally decided that they were going to sit earlier, I infer, and read out a prepared statement. But I infer that there was some form of communication, perhaps direct or indirect, between Griffith and Reid in the morning. I think they still had the telephones in Darlinghurst at that stage, and I suspect it was a telephone conversation where Reid asked Griffith to delay saying anything publicly. So Griffith did have a prepared screed that he did not use at that time. Because the sitting was a bit delayed, and because this case was in Melbourne, Griffith's son, who was his tipstaff, sent a telegram to the registrar, Mr. Castles, in Melbourne, saying, expect another telegram by noon telling you that there is going to be an adjournment of next Tuesday's case, so that you can notify the parties. Castle was expected to work until noon on Saturday. He waited around until 12:30 and had not received another telegram. So Castle went home. The telegram arrived about half an hour later from Griffith's son. He says he sent it earlier. Anyway, that's the story. So what happened was that the parties weren't notified that the trial was being adjourned until Monday morning. And of course it then made the papers, and there was a scandal, and there was wasted costs, and the parties hadn't been heard on the adjournment. And Griffith publicly, from the bench, castigated Castle for having been in dereliction of his duty by going home at 12:30 on the Saturday. So Simon held an inquiry, and he produced a report which vindicated Castle and said that he'd been unjustly accused by Griffith. That's what happened that day.
I think we have time for one more.
Nick Baum, solicitor. There's clearly a rich vein of material held in the High Court basements, Your Honour, which we've all enjoyed this evening. Without wanting to preempt the Court's future expenditure and in the spirit of judicial accountability, when will all of this material be digitised and made available online?
Well, we have a project which I just think has been substantially completed, of going back through unreported judgments over the last century or so and putting them online. This stuff probably should be put online. I should say not everything came from the basement. Griffith's papers are in the basement, and so we were able to obtain some of the one side of the correspondence effectively from there. The other side of the correspondence and the handwritten notes are in Simon's papers, which are held in the National Library, and it was really quite interesting going through his papers. What I was unable to find was his will. He lived until I think he died in 1932, and the Supreme Court of South Australia struck certain words from his will on the basis that they were scandalous. I wanted to find out what these words were, but I couldn't find a copy of the will in the papers.
Thank you very much. Justice Gageler, I'm really so delighted that you were here this evening, generously giving your time to illuminating this really fascinating little corner of our constitutional history, and for linking what could be seen as just a fractious interaction between personalities over office furniture and expenses to really core constitutional principles of judicial independence and the role of a court in a federation. And I was reflecting that how vividly you've shown us that this mixture of personality and principle characterises the development of our constitutional institutions as a whole. I was delighted to hear that there was a 12,000-word paper that I hope that we will see in print. Even more delighted to hear that there might be 2 more lectures in this series. I would hope that at least one of them might possibly be given at Melbourne Law School, because you've given us such a terrific evening this evening, and I'd like to ask all of you to join me in thanking Justice Gageler.